Hello, students. Now we'll be covering an important topic, part of a module, that is drafting skills. See, why drafting skill is important? Because that actually gives you way to approach the court, right? So, legal draft is nothing, but it is something like putting facts of the litigant into a legally enforceable document. And it is an art and science of translating complex legal rights, factual narratives, and statutory remedies into structured, formal, written documents. It transformations client intention into legally enforceable formats, demanding meticulous word selection for absolute clarity, ambiguity mitigation, and effective persuasion. So, why this legal drafting is important? Because until and unless you have a good draft before the judge will not listen to you, and he will not be able to appreciate the facts and your contentions which you are going to put forth in your case. So, until and unless the judge does not understand what you are proposing and what your claims are, the court will not issue summons. So, if you have a very good draft, right? So, if you have a very good draft, the court will appreciate the facts and then subsequently issue the notice to the defendant to appear before the court and to adjust the claim, what your claims are, and so on, right? So, importance of legal drafting, it gives a foundation of legal action, the absolute bedrock of any civil suit, criminal defense, or legal transaction. Accurate translation of intent, capture and protects client core intention, ensuring rights are formally recorded and legally guarded. Establishing cause of action clearly delineates exact legal wrongs and corresponding statutory remedies sought from the court. First impression on the bench act as the primary lens through which a judge initially understands and evaluate the dispute's merit. So, as I said, until and unless you put forth a clear and crisp fact before the judge will not be able to appreciate the facts and not be able to summon the defendant, and then and there can dismiss your case itself. So, principle of good legal drafting. See, the first principle and foundation of a good drafting is clarity and precision. You will be able to communicate what your client's intention is, and you'll be able to communicate the core intention and subsequently transform into an legally enforceable document through which you can get your claims, remedies, and so on. Logical flow of facts, present material facts in a strict step-by-step chronological sequence. This ensures judge can easily follow the narratives from dispute origin to legal conclusion. Appropriate use of legal language, balance necessary legal terminology with readability, avoid excessive archaic legalese that obscures the core message and hinders understanding. And brevity, exclude irrelevant background noise, emotional venting, or repetitive statement. Focus exclusively on material facts required to establish the cause of action. So, see, the chronology is very important while making a draft. You have to show the court how you can say that what is your position if you are approaching the court. Why are you approaching the court? That has to be very clear. What is your position at the time when your right was infringed, and subsequently you have to put forth how and why the defendant is involved in the transaction. So you have to be very carefully and meticulously draft such a legal document, due to which the court will be able to appreciate your exact cause of action and claims and subsequently provide you the remedies for it. So, overview of order 1 to 10. See, these orders provided under CPC are, I would say, the important orders, uh, because that eventually help you to build a good legal draft. So, order 1 says parties to suit. Now, who can be the parties to suit? Two parties are there, right? In any suit, one is the plaintiff, the other one is the defendant, right? And in criminal, there is a complainant and the accused, but that's a state case. So that does not pertains to CPC. CPC is a core procedural um, statute that deals for civil cases, right? So order 1 says parties to suit determines exactly who must be involved in the litigation, covering joinder, misjoinder, and non-joinder of plaintiffs and defendants. So see, the joinder of a party in civil suits refers to inclusion of multiple plaintiffs or defendants. So, of course, there could be multiple plaintiffs and defendants. Let's suppose in a suit for partition. In partition, a plaintiff is defendant, defendant is plaintiff. There could be multiple plaintiffs and there could be multiple defendants in such scenarios. In case of money recoveries and in case of any dispute, any civil dispute pertains to the same transaction. If both the parties, like the plaintiff one and the plaintiff two, has a similar cause of action, similar transaction, then they can be joined as a plaintiff altogether in a single plaintiff. So there are two connotations as well incorporated in order one. There is the non-joinder. So when a necessary party to the suit is omitted. So when there is a necessary party to a suit, without whom the court cannot adjudicate the matter efficaciously, right? So that party has to be joined in a plaint. So it becomes a necessary party to the suit, right? The other one is misjoinder. It involves incorrect inclusion of parties to a suit who has no substantial connection. Of course, who does not have any claim before the court. Why to add that particular party to the suit, right? So it becomes a misjoinder. So moving further, order 2 talks about frame of suit. So it mandates that a suit must include the whole claim the plaintiff is entitled to, preventing claim splitting and multiple lawsuits. So the core idea of this order is that whatever the claim plaintiff has to be put forth in a single plaint. So it avoids the multiplicity of the suit itself. Right, so order 2 rule 2 clearly says that whenever you claim a particular amount, let's suppose in money decree, if you're claiming, let's suppose you have 2 lakh of claim against the defendant, right? And you're just claiming 1 lakh out of 2 lakh. So this order 2 rule 2 bars you to subsequently file another suit for another 1 lakh rupees, right? So the intention of the legislature is very clear that it avoids the multiplicity of the suit. So there is a reason why this provision has been added in the statute. Order 3 talks about recognized agents and pleaders. Now establishes who is legally authorized to appear, of course, who has a claim, who has a better claim, act or file application in court on behalf of a litigant. So of course, that becomes us. A lawyer can represent, right? Solidifying the role of legal representatives. Order 4 says institution of suits, lays down the foundational rule that every civil suit must legally commence by representing a formally drafted plaint to the court or designated officer. Of course, if you have a remedy, so how you will approach the court? This provides you how you can institute the suit. So as I said, the procedure, which I have already discussed in module 1, I'll also discuss in this module as well, like how the draft should be prepared, what headings should be there, and what topics should be there, like index, memo of parties, then your claim, the plaint, right? So this is how the institution of suits begin, and you can directly file before the court. Now, once the suit is being instituted in the court, what court will happen? What court will do? So first of all, the court will hear your summoning arguments actively. If you have a good draft, the court will appreciate the fact and subsequently issue the notice to the defendant. So order 5 talks about issue and services of summons, dictates the formal procedure for notifying the defendant that a suit has been filed, compelling their appearance and setting defense timeline. So in civil suits, the timeline which the defendant gets to reply back the plaint is of 30 days. A written statement has to be filed once the notice has been received by the defendant. The defendant has to give his reply within 30 days, right? That's how the reply should be made. And in that written statement, he can further claim XYZ, like he can file an application under Order 7 Rule 11, 7 Rule 14. There are multiple applications which the defendant can file along with the written statement, set off application or counterclaim. So once the counterclaim, that I'll discuss in Order 8, that will fall under the purview of Order 8 when we'll specifically talk about the written statements. So Order 5 usually talks about the issue and service of summon. Order 6 talks about pleadings generally. The master guide for drafting, mandating that pleading must state only material facts and not the evidence. It also covers amendments, signing, and verification. So, very important application which we lawyers usually put forth before the court is 611. Let's suppose if I made any mistake in the plaint and because of hurry, I filed it before the court. Right? So, now some new development happened in the case and some new document I procured from the client. So what would I do? If the material statement is being uh, made by the client that this has to be incorporated in the plaint, so we can move an application under 611, Order 6, Rule 11. It talks about the amendment of plaint. So you can subsequently amend the plaint also. You have to take the leave from the court, moving an application under 611, stating the facts that why you wish to amend the plaint and why you haven't made that particular clause or paragraph previously in your original plaint. So you have to